The next case is Mariano Romulo versus Seattle Public Utilities.
Morning, Your Honors. Gary Manka, I represent appellant. I'd like to reserve 3 minutes for rebuttal. May it please the court, and I'd just like to echo everyone's sentiments to thank the Tukwila Justice Center and the Tukwila community for welcoming us here. You've been very gracious and helpful. Let's start with the question of whether the trial court's jury instruction correctly stated the legal definition of an adverse employment action under the Washington law against discrimination in the context of retaliation as opposed to a disparate impact claim. To answer that question, we think the best sources for this court to start with are first the text of the statute, second the purposes of the Washington law against discrimination. We also think that the case law supports our argument, but the case law can be read to point in a couple different directions, and also there's some concerning dicta in the case law, such as Marin v. King County, suggesting that an employer has no liability under the Washington law against discrimination for retaliating against an employee so far as the employer can yell against the employee, threaten to fire them, and that's not an act that is enough to trigger legal liability under the statute. So if we start with the text of RCW 4960-210, it tells us that an employer may not engage in discrimination that is motivated by retaliation. And that word indicates that an employer may not treat an employee differently in a way that's negative at all. It doesn't suggest gradations of actions. It doesn't suggest that it's illegal to do something against the employee that we're absolutely certain is going to deter the employee from bringing a charge or testifying in a discrimination case against that employee's employer. And it also doesn't suggest that there are even de minimis acts that are okay. That you can look at the employee with, you can be unkind to them, not invite them to social lunches, suggests that any discrimination whatsoever is impermissible. So on this spectrum of acts that constitute discrimination, my client isn't even going so far as to say any act whatsoever. We're just saying that on the continuum of acts that are impermissible, it's not so far over here that we have to be absolutely certain, or under the test that the city proposes, that an active employer would have deterred an employee from engaging in a complaint against discrimination. So we're just saying that the continuum is even a little bit over here, that if an act could have or might well have deterred an employee, then that is sufficient to trigger liability. And if we think about the purposes of the WLAD, which case after case suggests is critical to interpreting what the statute means and what it requires in a given category of cases.
So are you saying that that if you look at Burlington, if you do, it's not the model of clarity in terms of that definition, because it clearly uses the word would have, and then it goes on to talk about that they could well dissuade a reasonable worker. Are you saying that both of that could well should replace would, or that the instruction should have had an additional instruction that said this is what that means, could well have?
Are we saying that's what the instruction should have said in order or that's what Burlington should have said.
In this case, because it seems to me what you're saying in this case is they only used the word would. They didn't tell them anything about the language in Burlington that says could well dissuade a reasonable worker. Are you saying that they should have only used the could well dissuade a reasonable worker? Or are you saying that they should have used the definition about would have and then use it the same way they did in Burlington, which is sort of later to talk about it in that context, that they could well dissuade a reasonable worker?
And let's just be clear, it said might well have in Burlington. It didn't say could.
Thank you. Yeah, you're right. It said could and then might well have. And then Judge Mathieu, you're absolutely right. So I think one of the confusions from Burlington, and I think the way to look at it is it provides tiers of definitions. Is it says that an adverse employment action means something that would be materially adverse. So it talks about this concept of material adversity to distinguish that type of action from something that actually involves the change of terms and conditions of employment. Because the Supreme Court held under Title VII that in the anti-retaliation context, a plaintiff doesn't have to show a change in the terms and conditions of employment. So it introduced this concept, it would be materially adverse. But then it went on to say what material adversity means is that any act that could or might well dissuade an employee from engaging in opposition against discrimination. And so I think that's the distinction, Judge Bowman, is the court could have said an adverse employment action means an action that would be materially adverse, and materially adverse means an act that could or might well dissuade a reasonable employee. But we think it's not necessary to provide just that initial sort of throat clearing of it would be materially adverse. Because what matters operationally is ultimately, could it have dissuaded a reasonable employee or might well have dissuaded? And I think our argument is ultimately supported by the Supreme Court's analysis when it adopted the Burlington Northern test, because again, in sort of an initial discussion of black letter principles, where it perhaps wasn't as careful as it could have been, it used the word would, but when it came to actually apply the test to the facts of the case, it used the language that we think is a correct articulation of the test. I think I'll reserve the rest of my time, my extra 13 seconds.
Thank you.
Good morning, Your Honors, and may it please the Court, Ryan Groshong, Arnold Porter, on behalf of Defendant City of Seattle. Your Honors, the trial court did not err by instructing the jury, consistent with Washington law and plaintiffs' prior proposed instructions in the first trial in this case, that an adverse employment action in the retaliation context is an action that would dissuade a reasonable employee from making a complaint.
Should there have been a definition of would for the jury? Because in Burlington Northern, it says in this context, it means might well have dissuaded. Should there have been a definition instruction with regard to that?
No, Your Honor, I believe that the word would sufficiently defines the standard for jurors. That's Washington law as it's been articulated by this court in the first trial in this case, as it's been articulated in the Bittner case, as it's been relied upon by the Washington Supreme Court, which stated that the Division II formulation of the test in Boyd was persuasive. That standard has further been relied upon by circuit courts around the country. And even in certain cases, there have been references to both the would have standards and the might well standard, meaning that there seems to be some acknowledgement that these standards are in some senses interchangeable. And if there is some appreciable difference between the standards, it's not implicated by the facts of this case. For instance, counsel just raised the scenario in which an employee could be yelled at by her supervisor, and that wouldn't rise to the level of an adverse action. We don't have anything in this case remotely approaching that level of severity. If anything, the record is clear and the testimony was uncontroverted that it was plaintiff, not his supervisor, who became heated and argumentative in his communications with his supervisor, not the other way around. Nor did the trial court's instructions require the jury to find that all of the adverse actions at issue were motivated by retaliatory animus, particularly in light of both parties' closing statements, which emphasized the correct liability standard. And even if there were some showing of instructional error of any kind, plaintiff who refused to do his job, threatened his coworkers, and generally failed to put forth evidence of retaliatory animus either in the trial court or in his briefing to this court, cannot show prejudice, and this court should affirm. Turning back to the question of the could have versus might well standard, I also wanted to note a few points regarding the way in which that standard has been relied upon in this case to date, as we are here on the second appeal following the second trial. First, the plaintiff twice proposed to the trial court in the first trial in this case the precise instruction that he now contends misstates Washington law.
Well, to quote Maya Angelou, when you know better, you do better. So maybe he's just saying, now I'm doing this trial again. I want to use the instructions that are appropriate.
And I appreciate the quote and the sentiment. The issue, Your Honor, is that plaintiff urged that language to this court. The court adopted it in its first opinion in this case. In his brief to this court, plaintiff stated flat out that an employment action is adverse if it is harmful to the point that it would dissuade a reasonable employee from making a complaint. That's the very language that he now claims is a misstatement of Washington law. And this court, in turn, adopted the Boyd standard and stated that it was error for the trial court not to issue the instruction that plaintiff requested. And so this isn't just an instance, Your Honor, of plaintiff learning better and doing better. This implicates both judicial estoppel and law of the case in that if plaintiff believed that the instructions that he requested in the first trial were misstatements of Washington law, his opportunity to do that or his opportunity to rectify that was in the first appeal before this court, in which he urged the standard that he now misstates the law.
Was that standard at issue in the first appeal?
The issue in the first appeal, Your Honor, was that the trial court one of the issues in the first appeal, I should say, is that the trial court did not issue an instruction that allowed the jurors to consider adverse employment actions short of termination. Based on the trial court's instruction, only the termination was issued. But as evidence of, or rather as demonstration of the instruction that the trial court failed to give, plaintiff urged the trial court should have been given the instruction based on WPI 330.06, which he twice offered.
So you are arguing that it was litigated fully, the same issue?
That's correct, Your Honor. In arguing that this instruction should have been given, that this issue should have been addressed, plaintiff offered up both to the trial court and to this court.
I have the advantage of having been on the panel in the first appeal, and I don't recall us addressing this issue. I do recall us addressing the instruction, but for a very different reason. So does that make a difference?
Your Honor, what I'm saying is that the court addressed the instruction and stated in its opinion that the plaintiff persuasively argued that the trial court's failure was in not giving the WPI 330.06 instruction that he twice offered to the trial court. And so there is a distinction between arguing the propriety of that instruction versus the one that the plaintiff now urges. I don't mean to suggest that that was litigated in the first case. However, Your Honor, the failure to give the instruction that he now states was a misstatement of Washington law was in fact litigated. The court adopted plaintiff's position. Plaintiff is therefore prohibited both by judicial estoppel and by law of the case to continue to litigate the issue here. Moreover, as previously noted, even if there were some appreciable difference between the standard that's been adopted by Washington and the other circuit courts that we've identified in our briefing and the lower standard that he now advocates, the circumstances in which such a slight difference may be implicated are not presented by the facts of this case. Plaintiff likewise fails to show that the trial court's instructions required him to prove more than one adverse action that was motivated by retaliatory animus. Read in their totality, the trial court's instructions properly informed jurors of the actions at issue and allowed plaintiff to argue his theory of the case.
What about the fact that the specific adverse actions were limited to this list that were in the Romulo 1 opinion?
Your Honor, the court's limitation of the adverse actions at issue has to be understood in the context of the way in which plaintiff relitigated this case after it was remanded. First, insisting that his termination remained at issue even after this court had stated unequivocally that it was not. Second, serving discovery requests that were entirely focused on his dismissed claims. And then third, at trial, continuing to offer throughout the case evidence and testimony that related solely to claims that had already been dismissed. And so for all of those reasons, Your Honor, the trial court's limitation of the claims was reasonable in light of plaintiff's approach. And even putting that aside, the only two specific adverse employment actions that plaintiff has articulated and claimed should have been presented to the jury are his being placed on administrative leave in 2017 and his not being hired into the manager position. As to the administrative leave, as courts have recognized, administrative leave that leads to termination is part and parcel of a termination. The termination had already been fully litigated. It was no longer at issue. With respect to the failure to hire claim, plaintiff was permitted at trial to put on evidence and testimony relating to the alleged failure to hire. There was no evidence or testimony about who actually made the decision not to advance plaintiff's candidacy. And so the jury had no information about who made the decision, whether they were even aware of plaintiff's protected activity, and if they were aware, whether it led to any retaliatory animus on the part of the decision makers. And so without such evidence or testimony, Your Honor, it would have been error for the trial court to instruct the jury on a theory that was not supported by the evidence or testimony.
But there wasn't any CR 50 motion by you all. There was no ruling that there was insufficient evidence to present that last claim of the failure to hire to the jury, right?
That's correct, Your Honor. The city's CR 50 motion did not address the failure to hire claim. I can see my time is up unless there are further questions.
Thank you.
Thank you.
I think that just common usage of words is helpful here to understand the distinction between would and could and might well have. If someone asks you a question about some past event, or say I was talking to my kids, and would you, let's say instead of only this dinner, I had also said you could have ice cream after dinner. How would that have affected what you would have done with your dinner? Well, I might have eaten dinner instead, or yeah, I would have eaten dinner instead. Would connotes certainty. As a dictionary definition suggests, it's a presumption that something would have happened in the past.
Is it might have or might well have?
It's might well have, or could. So I think those words, particularly in close cases, matter. And should this court do anything about those differences, I think is a question that again can be answered by referring to the animating purposes behind the Washington law against discrimination. So if we remember that an employee has to show that the employer was substantially motivated by this retaliatory animus. The question then is, so what can the employer get away with? And we're even conceding that there are certain de minimis actions that the employer can do, even if they have that kind of animus. And that's not enough to trigger liability, because there are cases that suggest ultimately this is a law that shouldn't become a civility code. But on this spectrum of acts, we think it goes too far if there's a requirement that an employee show this would have deterred me from filing a charge or testifying in court. So right where we are, right where we think Burlington Northern was, is the proper test for this court to adopt. And we do think it's important to consider hypothetical scenarios that aren't presented by this case, because this is a rule of law that this court is adopting. And again, case after case says that the answer to these questions needs to be based on the animating purposes behind the act. So employees aren't going to come forward. They aren't going to report discrimination if they think my employer can yell at me or threaten to fire me, because maybe I'm going to have a hard time showing that that would have deterred me. So the greater protections offered by this broader test for liability is what aligns with the purposes of the WLAD. We ask that this court reverse the judgment of the trial court and remand for a new trial.
Thank you. This matter is submitted. The next case is Michelle Zimmerman versus